Okay, let's call this meeting to order. Please stand for pledge of allegiance.
It's outside.
Where is it?
It's in the lobby.
Okay, it's in the lobby.
It's in the lobby.
Everybody else.
I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I'm Marvin Day, your board president.
Kathy Clark, Vice President. Karen Peltier, Director.
Roger Barnes, Director. Bill Ferguson, Treasurer.
Bob Bonaccorsi, Secretary.
Mac Wimbush, Director.
And tonight we have with us two members of our new law firm, Adam Sterling, David Rico, okay, and Thomas Quillen. Okay, I have no announcements, so let's go straight to homeowner input. Do we have any?
I don't have any forms in the back.
All right, well then, let's get to the main purpose of tonight's meeting, which is as part of the retainer fee for the new law firm, they include a new board member orientation, and that will be presented by Mr. Quillen.
So I will just give a little quick introduction about our firm. We are the biggest HOA, common interest development law firm in the state. We have about 25 attorneys. We cover all of California, from Sacramento all the way to San Diego. A lot of firms have HOA departments. We are an HOA law firm. This is what we do. This is what we specialize in. So this board orientation is something that we've put together for our clients. So we understand that sometimes it's new to a lot of homeowners exactly how the board works and operates. So this is us trying to educate and put that together for everybody. All right, I hope you enjoy it.
So it's very nice that so many of you came out. I appreciate that. The purpose of this evening, board orientation, for the most part, is directed for the directors themselves, but also gives you guys a good idea of the responsibilities, duties, legal duties that the association directors have in relation to functioning, operating as a board of directors for your association. Directors are held to a higher standard than a member of the association. There are additional things that they have to do or will do that are required by law under the Davis-Sterling Act and even under the Corporations Code. So I'm just going to start. I apologize. I'm most likely going to be directing most of my conversation to the board, but clearly, if you have any questions at the end, I'm more than happy to address those from the audience too.
Can I just stop you?
Yes.
If you could use the mic.
What I've noticed on the videos is that when our directors are not right on the mic, it's hard to hear on the video. Thank you very much.
So what we have done is we actually produced a special board orientation packet. Each of the board of directors has received one of those before we started. And there's very specific information in here with regard to duties and obligations. The two biggest issues facing any board of directors is their fiduciary duties and their duties of loyalty. I'll be honest, I'll spend more time on this probably than anything else. Only that this is very important both for the membership generally, but for the directors to understand that they do have obligations to do certain things. If they fail to do those things, it will cause problems with the association, but there is also a possibility, or a great possibility, that the directors can take themselves outside of the protection of errors and omissions or D&O insurance for protection of the board in the event that there is anyone that files an action against the association or the directors that could take themselves out of that and into a personal liability situation. That's something we want to avoid, and avoiding that means that the directors just do what they're supposed to do under the law. It's very helpful for them. So the duty of care, fiduciary duties and duty of care. The primary purpose and job of the association directors is to be informed about the association's business, and that they have to make sure that they use their own judgment in making decisions. That's a very important thing to remember, that each board of director needs to do their own independent thought process in relation to any issue that comes before them in the board. If that does not mean you cannot rely on people. For example, you can rely on counsel, such as myself. You can rely on your manager for collecting information, or any other third-party accountants or anyone else to actually gain the knowledge that you need in order to make a valid decision or a correct decision. So the duty of care is much different with regard to a director, and that there is a heightened level. However, a director does not reach the level, for example, of an attorney who has a license to practice as an attorney or a doctor, or an accountant who has licensing to be an accountant. You're not licensed to be a board of director. The difference is that you guys are volunteers, and it's a difficult job. And I realize that there are individuals in some membership that might get frustrated by the board and how they're operating sometimes. But I'll be honest with you, it's a very difficult task, and you guys have a very large association. So I know that they're doing the best that they can, and they also can only conduct board business during board meetings. That means that they cannot be doing and operating outside of the board meetings. So if, for example, issues come up, it has to be tabled until the next board meeting. Doesn't mean the information can't come in, but they can't consider or discuss it amongst themselves. There's no communication by email between them in relation to specific issues until the actual board meeting when they can actually have that discussion. So the things that, the mistakes that board of directors make or can make that takes them outside of the errors and omissions and errors in judgment is to fail to set up an adequate control or reporting systems. So I think based on my work with you up to this point, you guys already have that pretty well established. You also have a very good management company. Seabreeze Management is one of the better management companies that we work with on occasion with other associations and throughout the state. They are very good, and they do know what they're doing, and they're very helpful to the community. Failure to review reports. Every board meeting, board members will receive a packet. My understanding is that part of that packet is actually posted on your website with regard to the open meetings, which is not common. And it shows transparency with regard to the operations and functions of the board that a lot of associations don't do. So I think you guys should appreciate the fact that you guys are operating in that manner. Drawing improper conclusions with the information provided. Failure to attend meetings, that's a very important thing with regard to the board of directors for associations, is that you have to regularly be able to attend meetings. If you're missing meetings, at some point that board of directors becomes ineffectual and they really do need to be removed if they can't consistently attend. Clearly that doesn't mean that you have to have someone that attends every single meeting in the event something happens that they can't be there. But there's always the option to call in for board of directors to participate in these meetings. They don't have to be here in person. They do have an option to call in, and you can actually set up a conference call to allow them to be involved. Failure to discipline the officers when they exceed their authority and do illegal activities. That goes to, I'll try and give you an example. So there's been on occasion where a board of director will actually run for the office in order to gain something for themselves. So that officer will do something with regard to the board in order to get, say, a washer and dryer installed in a high-rise condominium complex where they're the only ones that have a washer and dryer in their unit. That then overloads the drainage system and actually causes flooding and damage to the building. But the point is that they utilize that position as a director to gain something for their own, for themselves, to their benefit of themselves. If the other directors participate in that, they're equally as guilty. If if they do not investigate that or call that person for doing that, they can also be found to have liability in relation to that. So it's very important that, that the board of directors discipline within the actual directors, similarly to what you would do with disciplinary actions for violations of the governing documents by any of the membership. There are violations of acts by the board of directors that also similarly would need to be disciplined within the directors. Disclosing privileged information. This is and can be one of the bigger problems that we run into as legal counsel for associations. I think you guys know, but there are executive sessions that are called with regard to the board business. And those executive sessions are limited to certain subject matters that can be held in closed session without membership being participating. Legal actions or potential litigation is one. Disciplinary actions against membership because of you don't want to have a member being called for disciplinary action in front of the other membership of the community if you can help that. Now, that doesn't mean that that member doesn't have an opportunity to request that their disciplinary hearing be held in open session. They can choose to do that, but we don't recommend, but you can do. But as far as the directors go, they'll always do that type of thing in closed session, including any type of foreclosure action on unpaid assessments. So there's about 5 or 6 things that you can actually do in executive session, and that's it. You can't conduct board business that otherwise has to be conducted in the open session. Otherwise, you're in violation of the Open Meetings Act. Exceeding the scope of authority. That usually goes to again, like personal matters with regard to that you approve a contract or universally approve a contract as an individual director, force the association into something that otherwise wouldn't be done but for that director's actions. That takes them outside of protection of your D&O policy. The measure for directors is controlled by what is called the business judgment rule. That's the measuring stick which the court uses in the event that there's actions brought against the director by any of the membership. And any type of litigation, the judge will apply the business judgment rule to determine whether or not a director is in violation of their duties as a director. There's a lot of deference given to the business judgment rule. The directors, as long as they act in good faith and in a manner in which the director believes to be in the best interest of the corporation, and with such care, including reasonable inquiry, as an ordinary prudent person in a like position would use under similar circumstances. As long as they meet those 3 requirements, even if it ends up being that the decision ultimately by the board is incorrect or has to be corrected, or it isn't corrected but may not be the best solution, as long as what they are doing is reasonable under that business judgment rule, the court's going to uphold that action of the board of directors. So whether you 100% agree with everything that your board may do in relation to the community doesn't necessarily mean that they're doing something illegal or wrong or improper. The next area is duty of loyalty. Duty of loyalty is loyalty to the actual corporation as a director of the corporation. That would relate to disclosure of information, like I said, in an executive session that otherwise shouldn't be disclosed, personal information, financial information with regard to specific members. Avoid influencing of votes. They should not be, directors shouldn't be trying to convince other people to vote their way by presenting evidence or information that otherwise the directors don't have. Each director has their own obligation to investigate to a certain extent everything that they vote on and try not to be influenced to vote a certain way because they feel pressure put upon by that other director. Fairness. There has to be an arrangement for fairness of treatment, that the director should be fairly treating everyone in the membership equally. There should not be any selective enforcement with regard to governing documents as to an individual. They should avoid trying to do any personal, I'll say, reaction to personally to any specific person, that everyone should be treated equally within the association. There also is the issue with regard to avoidance of appearance of conflict. And most of the time what happens with that is an association director may have some type of relationship with, or even an ownership interest in a vendor, for example, like a contractor or even a landscape contractor. They may be considered for being hired by the board to do work around the community. What they do have to do is disclose that they have that vested interest or independent or individual interest, and they actually have to recuse themselves from participating in anything to do with that particular contractor. And it's left to the other directors to make that decision whether that person's retained. If it's found out after the fact, that's most likely going to result in some type of lawsuit against that director. Because it's self-serving, and that is directly we breach of duty of loyalty to the association. So clearly, anyone that has a ownership interest or business interest, or even, I'll be honest with you, if they have a special or a friendship relationship with a specific contractor, I would recommend most likely that you as a director would not recuse yourself from that to avoid the perception that you guys are somehow working to benefit someone that you have a personal interest in. So conflicts of interest, there's a number of areas that can happen in. We included a page with regard to the civil code section, and it's pretty dry, but it's worth reading. I'm not going to read it through for you guys because it's just, it literally is civil code section 5350B. And it just goes to the various nature and types of conflict of interest that the board of directors has to be cognizant of when they're actually functioning as a board director. The general duties of the directors for the association. I think that one of the problems with community associations such as yours is that most people don't actually understand what the board of directors' role is in relation to operations of the association. The primary duties of the director is to collect the dues and preserve the funds, keep the common areas in a state of good repair, and enforce the governing documents. That's the three primary things that they're responsible to do. Enforcement of the governing documents is a very broad area because clearly they're your CC&Rs and bylaws and rules. There is potential for violations, many types of violations that can occur, and that can actually eat up a lot of time for a board of directors. I recommend to everyone that they are very aware of and read through the CC&Rs if you haven't already, to make sure that you understand what you can and can't do with regard to living in this community that's very beneficial to you. There are 4 positions with regard to your board. There's the president, vice president, secretary, treasurer, and then directors at large are the remaining 3. There are specific duties that are assigned to that role as president and those other positions. The president is the one that normally will chair or run the meetings. They usually are they're the control of the meetings. They control what happens in the meetings during the open session. They also act as a liaison normally between the board and the association attorney, unless that president or the board specifically picks another director to be the liaison with the association's council. This is a very important thing. There are a lot of associations that don't do this, and it ends up costing the association and membership a lot of money for legal fees because every director is sending information or questions or email to association's council, and it eats up a lot of time. I'll be honest with you, policy is for our firm is if we get an email, it's a 0.2 charge as a minimum charge for us, no matter what the email is. So if you're getting an email from 7 directors versus 1 director, clearly that's a big difference in time. So it is very important that they do select a person to interact. There are times when you will specifically assign a director based on the nature of or a specific issue that may be need special attention or a special director appointed. But that person would then be limited only to contact with the association council with regard to that issue. The vice president's duty really is to step in when the president isn't available. The secretary oversees the taking preparation of the meeting minutes and works with the manager to make sure that all the minutes are prepared, they're reviewed, and then they're approved by the board. The treasurer oversees the association's finances. This is always kind of a sticky situation, in my opinion, because the treasurer, a normal treasurer of a board of directors for a corporation would tend to have some type of accounting background or some type of financial background, banking or otherwise. You don't always have that happen when you're in associations such as yours. The duty of the treasurer is to just make sure that they actually do review the finances. The actual payments and a lot of the actual handling of money is actually handled by your management company at the direction of the board. The point of the treasurer is not necessarily to actually cut each of those checks to your various vendors. The role of the treasurer is to just make sure that they are aware of where all that money is going and reviewing the various financial records each time before the next board hearing to make sure or ask questions with regard to where money is going and why it's going where it is. It's very important, and that's actually a very important role with regard to the directors. So I've already said this, but they are volunteers. A voluntary board for a nonprofit corporation, they don't get payment for what they do. I will say that they don't always necessarily get praise for what they do from the association membership, but it's really great, and I will say that I'm very impressed with the fact that you guys can actually see the 7-member board, even at the size of your community. We have difficulties in a lot of associations for getting enough people that will even be willing to run for the board of directors because of the nature of the job and the burden that it puts on them. With regard to vendors, it's very important that you guys understand that as with regard to vendors for landscape contractors, management even, that it's a director's role to conduct business for the association is during the board of directors meetings. You should not be, as a director, going out and into the management company or even up to contractors that are working for the association and tell them what to do. That's not your job as a director. You shouldn't be doing that. I'd recommend you highly that you don't do that. Most of that should be handled through the management company at the direction of the board, and the management company then will handle the day-to-day business in between. That similarly goes for direction of the management company and your manager. I know that there's a tendency to want to act quickly when it comes to certain things, but to be honest with you, unless it is an emergency, you really can't, and you shouldn't, unless you call a special meeting, which is not necessarily something I would recommend doing that frequently. But you gotta make sure that you do not abuse your manager and start giving contradictory directions to them. That's something that should be done during the board meetings to determine what it is that you want your management to do. Normally that is set forth in the contract with the management company as to the scope of their work that they actually handle. That's very important for the board of directors to understand what it is the management is actually tasked with doing. If you haven't reviewed the management contract, I would recommend that you each take a look at that, at least to get an idea of what your manager is supposed to do and what they can do for you. I can't remember, do you guys actually have employees beyond the management company, like individual employees? That's good. That actually can create more problems than when you actually have to employ, if you have your own employees for the association, it creates a whole new level of issues that you guys will never have to deal with. So with regard to the board meetings, I think that you guys actually do a pretty good job of that from what I can tell. And from what I've seen with regard to your agendas posting and information information that you post on that. Your manager is, again, very good at what they do, but there are certain rules that you have to follow with regard to posting of agendas, for example. For a general meeting, open meeting such as this, you have to post that agenda at least 4 days prior to the meeting in order to have that meeting be a valid meeting. You have to post it 2 days prior to an executive session meeting. Or you can post them both 4 days beforehand, so most of the time you're going to run your executive session and your open meeting on the same evening, so you don't end up killing 2 days instead of one. So the notice has to contain the agenda for the meeting, and what's posted on that agenda is what the business of the association is for that night. It can't go outside that scope of that agenda. And the reason being is that if there's an agenda item that's not on that agenda, that is discussed in an open meeting between the board of directors and some decision is made, that does not provide an opportunity to a member that may have interest in that particular agenda item that didn't show up for that hearing or for that meeting, to have the opportunity to actually have any input with regard to that particular issue in the open forum for the board meeting. So it's very important that you stick to the agenda. If there's something that comes up and comments that are raised or questions that are raised from the audience, from the membership, and during the open portion of the meeting when they actually have an opportunity to present information to you guys, you can respond to the question if you choose. Most of the time I would recommend that you take it under submission to actually take consideration of it and investigate it, instead of just on the fly answering it and then end up being incorrect or having to correct yourself after the fact. You guys have a very good forum, much better than most. You actually have an entire room dedicated for conducting your board meetings. I also have been informed, and I imagine you all know, but they actually do videotape all their open forum sessions, and you guys can access them on the webpage, and they maintain those video on the webpage for up to a year. That's unusual and not mandatory and not required, but again, I think that goes to the fact that you guys have a very transparent board of directors and a very transparent association with regard to the operations and business of the association. And that's an excellent thing. The more information that you guys have with regard to what the board of directors is doing and with regard to the community generally is very beneficial to the overall community. The one thing that I will say, and this is directed to the audience, and the board of directors needs to keep this in mind also. The Open Meeting Act is a requirement in which any type of board business that is conducted that isn't protected under those limited exceptions for executive session requires that you have the membership have the ability to come and observe the open session meeting. That does not mean that during the business being conducted by the board of directors, when they're deliberating or discussing issues on the agenda, that the membership has a right to interrupt, interject, make comments, get into discussions with the board of directors about the decisions that they're deliberating at all. That should not be something that you do. The right under the Davis-Sterling Act, under Civil Code Section 4900, with is the Davis-Sterling Act. The only right that you have as a board, as a member of the association, is come and observe the board conducting business. That's the purpose of them being here, is to conduct business. If there is frequent or interruptions with regard to actually conducting the business, you can end up taking a board meeting that should be only a 2-hour-long meeting to 7 hours. I mean, I've been at meetings for board of directors that have gone to 2, 3 o'clock in the morning because of the interruptions and the dragging on of the issues. And that is really unfair to them. It also doesn't make a clear record as to what's actually being done. So that's one of the things that I think the membership really needs to be aware of. That does not mean that you do not have a right to address the board. The board does have to is required to provide an open forum for the membership and the audience to come up and make comments. They can set time limitations on there. Normally, I would recommend with a bigger association that they set 3-minute time limits for each person that is coming in to actually speak with regard to a particular subject. You do have an opportunity to do that. The board can set that at the very beginning of the open meeting, at the end, or both, however they want to do it, but they structure the meeting and how it operates. But I really, really want to stress that you guys allow them to actually do the business that is on the agenda, get it done, so that you guys can all go home, but also so that the business is conducted properly and correctly. Recording of the meetings. Well, that actually doesn't really matter to you guys because you videotape all your open sessions. Normally, we would still, I will say, recommend or request that the audience doesn't actually record the meetings on their phones or otherwise. And the reason being is this. The recordings that are made by the association that are posted on the website are in their entirety, they're not edited. What happens is, and because of technology, the way it operates today, that there can be, and there is ability to take a recorded session of an open meeting or any meeting and actually edit it, that it comes out incorrectly. I don't know why anyone would actually do it, but I know that it does happen. So I think it's very important to understand that. That goes in addition goes to executive sessions. When you come in for disciplinary hearings as a member, if you actually have a violation notice and you're coming in for a hearing, there's no recording of executive sessions. It's in this state, in California, it's a 2-party consent law for recording conversations. So both parties have to agree. So it would be the member, and it would have to be the board of directors would agree to being able to tape that meeting. If you tape that without consent or without the knowledge of the directors, it's actually a criminal act. So you can be reported for doing so. Illegal wiretapping or recording of sessions without consent in California is illegal. Again, the reason that that is done and the reason that we don't allow recording of that is because we want to preserve the privilege of that meeting, also the information that is gained from the association board and that individual for that hearing. The problem being that if they take that information out and start disseminating it outside of the meeting, it throws away any type of privilege. It also potentially puts everyone in a bad spot, and I prefer that that never happens to you guys. One of the things that it seems simple, but I just want to make sure that you guys do, is how you make a motion. Functionally, the way that the board should work with regard to the agenda items is, or even with regard to making decisions for the board, is you make a motion with regard to, I move that we retain X landscape architect to redo the landscaping around the community building. Once that motion is made, then the board discusses it. So essentially each agenda item should start with some type of motion. So whatever that agenda item may be, I would just start, at least one person should start, I make a motion that we discuss agenda item number 3 with regard to. You do it, you discuss it, someone seconds it, after it's been discussed, if you come to a resolution, then you vote. Director of behavior. I don't think I actually see anyone that's a problem director for you guys, but there is proper decorum with regard to directors and how they should behave in their positions as directors of the board. They definitely can disagree with each other during the process of discussion with regard to board business. In fact, that's probably something that you'd like to see happen in the event that someone is putting forth something that really should be considered more, or that someone actually does disagree with. There is no requirement for a board of directors to be 100% in agreement with each other. With regard to your board, if you have a 7-member board, you only are required actually to conduct board business. you only have to have actually 4 board members present to make a quorum. And of that quorum of 4 that are present, you'd only have to have 3 vote yes and 1 vote no, and it would still carry as business going forward. The one thing that is very important for you guys is, as a board, once you come to a decision, and once that matter is voted upon, that the board all stay with that decision. Whether you were opposed to it or not when you voted, if you voted no, that's your choice as a board of directors, vote no. But once that actually is put in place, it's very important that you as board of directors support that position and stand in that position with regard to the action that's taken. And that means that I'll say that you don't want to undermine each other. As much as possible, it's very unproductive, and it actually causes quite a bit of damage to the association and the trust that the association members have in you. If the director goes out after a meeting and says to someone, you know, that was a really bad idea, I voted against it, I can't believe that they did that. I think that it's very important you guys stand unified once you come to the decision and support the other board of directors in the same way. With regard to the actual behavior of the directors when it comes to removal from office or censure, one of the things that you can do as a board of directors is, if an officer, president, vice president, treasurer, secretary, if for some reason that person is not functioning in the level that you believe is necessary to hold that officer position, the board of directors can, during the course of their tenure on the board, can vote to have that person removed as an officer and replace that person with another board of director. That doesn't require a vote from the membership. It doesn't require anything but the board of directors themselves making the decision that that person would be best suited not to serve as treasurer, for example. If you have someone that's stronger at it, or if someone honestly doesn't feel comfortable being the treasurer, even though they originally chose to be the treasurer, they can step down and another person can be appointed.
Excuse me, would that be done in general session or executive?
It depends on what the issue is.
What was the question?
Oh, I'm sorry. I asked if that was to be done in a general session or an executive session.
Well, normally the appointments of the officers is done after election, once the election is, and tabulation is done. Normally we recommend that the board sit after appointment and actually appoint the officers right then. With regard to removal of that person as in an officer status, it depends on what the issue is for the removal. If it's something that needs to be done, or it falls under the umbrella of an executive session with regard to, I'll be honest with you, if it has something to do with actual criticisms of that person, or with the job that they've done, or with regard to some action they've taken, I would say the most likely that would have to be conducted in a closed session initially. The disclosure of the removal of the officer themselves and the appointment of a new officer would have to be identified in the open session. And that goes similarly to that disciplinary action of a member. What you don't want to have happen is to have that information put out to everyone in the membership, and especially in open session for you guys. If you ever do something like that, because it's on video, then that means that that would be broadcast potentially to every single member of the entire community. And I'm not sure, do you have your video secured so that it's only accessed by members?
Yes.
Yeah, I was going to recommend that anyway. Anything that is, if you have web page access for anything with regard to your association, I generally will recommend that you have a portal basically just for membership only, videos of the open meetings, because by law, those meetings can only be attended and observed by actual owners of units in the association. Spouses who are not co-owners, or they're not on the property as an owner, technically cannot come to the board meetings. Not that I'm saying that you have to enforce to the strictness of whatever level it is, but what I'm telling you is that third parties should not be allowed to come into board meetings, especially counsel for some member, legal counsel, cannot attend an open board meeting without notice to the association. If they do so, they're actually violating their moral code of conduct and the code of conduct with regard to communications with represented parties, which is a violation of professional ethics for an attorney to come into a meeting without giving that proper announcement that they're going to be present, to give the board an opportunity to have me be here or to direct that person not to be here. If someone does bring in counsel or someone that you don't recognize as the board of directors, you can request those people to leave. If they refuse to leave, I would call a halt to the meeting until that person leaves. If they still refuse to leave, call the police department. There is definitely reasons why that you don't have third parties attend, including tenants. If you're actually renting out your property, tenants should not be attending these meetings. The owner of the property can attend the meetings. If there is, and the reason being, and I'll say as an example, if there's a disciplinary action that's issued against it because of a tenant's behavior or an action that's actually renting a unit here, even if it's like a nuisance dog barking issue, that violation notice is not issued to the tenant, it's issued to the owner of the property. The owner of the property is the person that comes to the disciplinary hearing. The fines that are assessed, if any fines are assessed against that owner, not against the tenant. Now, that doesn't mean that the owner can't do something with the tenant based on their lease agreement, but that tenant doesn't have involvement with the actual association. So, executive sessions, and I'm going to actually give you a list of the things that they can do. There's 6 items that can be discussed in executive session, and this is specifically set out in Civil Code Section 4935A through B. You don't have to remember that. I will also recommend to you guys that if you do have questions, that you can go to the Adams Sterling website that we actually have set up over multiple years. Adrian Adams, who is the managing partner of our firm, started that website many, many years ago and has been maintaining that for the benefit of associations throughout the state for years. It is an excellent resource. I'm not going to tell you that it's going to give you the answer. It'll give you answers. And you'll see in there, as with every good attorney, that every answer that we give you, we'll say, please consult your attorney. Because factually, nothing ever fits 100% accurately. There's no case that you'll ever run into that's 100% equivalent to every other case. It is a very good resource. It also gives you an opportunity, I believe, to answer questions. And the nice thing about it is searchability for us is everything we try and do with Adam Sterling is very plain English. We try not to be legalese at all. And it's our policy to try and be as straightforward with the English language as possible so everyone can actually understand it. So with regard to executive sessions, the 6 things that you can actually do is formation of contracts. So with regard to the bidding process, if there's bids that are brought in, and I imagine that you guys do multiple bids for projects if you possibly can, probably 3, because that's pretty standard practice for a board of directors and for the associations to have 3 separate bids at a minimum. They then discuss those bids, come to the conclusion as to who's best to be selected for, and then they will actually take care of the actual vote with regard to who they're going to retain for that contract. That information, after everything is said and done, will ultimately be disclosed to the membership, because that is a document that actually can be requested in a document request, but most of the time it'll identify that some type of action in the executive session was taken with regard to entry of a contract for. The other thing that is disciplinary hearings, which I discussed kind of more than probably I needed to, or more than you wanted to hear, but those are very important to you as individual members. And as far as the board of directors, keeping confidentiality with regard to that type of action is very important. It's very important to your membership. It also goes to the trust of the board and generally to the association. Litigation potential litigation or litigation. There are times where you may think that me coming in and talking to the executive committee or an executive session with the board of directors, it may be a subject that isn't actually in litigation. That's kind of a judgment call by the association's counsel as to whether or not it's potential litigation. And that is based on the nature of the claim that's being asserted and what's being discussed in that executive session from a specific member, or if there's any type of threat of litigation, then those matters can be discussed in executive session. And that's specifically done to protect the attorney-client privilege between the association and the board of directors. If that is broken, that privilege goes away and everything that is done by the association council can be discoverable. That's a very bad thing, because there are very much multiple steps that can occur in relation to litigation or any type of legal action that has been taken. There is recommendations made by association council, and there may not be just one option. That's where a business judgment comes in for the board of directors, even on that, is to, do you actually pursue litigation and put the association, for example, in debt for $100,000 in a lawsuit, or do you go to a mediation and you settle the matter for $5,000? It's both options. It may be the exact same scenario, the exact same fact pattern, and the exact same member. But that's a business decision. There are people that will always say, fight it to the end. There are people that say, you've got to settle it no matter what. But that is a decision that has to be made by the board, and that's part of the discussion that happens in the executive session that can't be disclosed to the membership generally. Employment matters, which you guys really are not going to have much of an issue with, other than your contract with your management company and manager, and that would always be handled in executive session. If there was an issue with regard to a specific manager, any manager, that the board wanted to call in that management company, that discussion would be done in executive session to avoid embarrassment for that manager. If there's specific issues about their work product or how they're performing their job. Payment plans for delinquent members of the association, same thing, similar to disciplinary action. That, for example, if you haven't paid your assessments for a number of months and you have an actual basis for which not to pay that, or you're in a financial position where you just cannot pay them consistently, payment plans with regard to delinquent homeowners can be discussed in executive session and should be discussed in executive session, again, for privilege or for privacy purposes. And the last one is foreclosure votes. So hopefully this has never happened, and hopefully you'll never have to do this, but if you run up a certain amount of assessments against a property that are unpaid by an owner, there is a point at which the association has to make a determination whether or not to file a mechanics lien against the property, or an assessment lien against the property to secure the debt. Foreclosure action is at the point at which the association decides whether or not they move forward after proper procedure to actually foreclose on that assessment lien. It does happen. It's not something that I like to see happen, but there are times when it does have to happen. So that is something that is also handled in your closed session, again, for privacy purposes. It also maintains the attorney-client privilege. With regard to attendance of the executive session, management is present during the executive session. That does not waive privilege. Management is an agent of the association board of directors. Similar as I am counsel for the association, I am also an agent of the association. So therefore, they can attend and will attend those executive sessions for purposes of maintaining records with regard to that, and also to present information to the directors with regard to specific actions that are being taken in the executive session. The other times, any other people that are invited to attend executive sessions is usually for the disciplinary hearings. That would be the individual member. The member has a right to bring in witnesses if they have information or evidence that they want to present. That does not mean that that person gets to stay in the room. It means that that person can come in, present the evidence that they want to present in support of that person that's at the disciplinary hearing, and then they will be dismissed out of the room and the hearing will continue. So that's the only exception for third parties attending executive sessions with regard to witnesses or evidence being presented with regard to disciplinary hearings or foreclosure actions, or with regard to payment plans or anything else that the member wants to have someone else provide them specific information that may be helpful to the association board. I'm not going to go over board minutes. I think I've seen your board minutes. Minutes there are very well done. Just make sure that the minutes that you take, especially the open meeting minutes, have to reflect what has actually occurred in the executive session. I'm not saying that you have to disclose what has actually been decided or even the nature of, but you have to at least disclose a disciplinary action was addressed, litigation, so it matches up to the actual agenda for the executive session. Defamation generally, and I'll say this is for everyone, not just the board of directors. Try to avoid name calling and making statements to board of directors and questioning their ethics and accusing them of embezzlement and accusing them of wrongful acts, illegal acts. It's non-productive. It creates a great valley between the directors. Unless you actually have evidence that they have done something like that, which is the only defense you have to a defamation suit by that director against you, if you're the one that's promulgating that information through email or otherwise to the other members of the association, it's just not productive. Similarly, the director should not be doing that either. If they do respond to somebody, which I will tell you, I don't recommend that directors respond to email that is directed to them by the membership. That if an issue is raised by a member to the board of director, that board of director then can bring it to the attention of the management, who then brings it to the open meeting to be discussed as board business. The director should not be unilaterally making decisions or even making representations with regard to what the board should do, because they cannot guarantee that that's what's going to happen. I'm not going to say much more about that, but be nice to each other. You all got to live here. And at some point, here's the thing, okay, I'm just going to say, here's the thing. At some point, one or all of you may actually sit on this board and run for the board. You know, treat them the way you'd like to be treated when you're sitting here. Maintenance issues and bidding policies. Probably not as big of a concern for you guys, being that you have the types of residences that you have here, other than this building and generally the common areas that are maintained by the association. But the 3-bid policy, that you got to make sure that the people that you're using are licensed and insured, that they have all the proper permits, and that you've approved the contract. I will say with regard to the insured part, you guys, hopefully, your management is assisting you with this, but there is requirements for insurance policies for contractors working in communities such as yours, that they have to have writers specifically to cover them for working in this type of community. If they don't have that and something goes horribly wrong, that insurance policy will say, nope. Then you're left with pursuing the contractor who tends not to have any money. So it's very important that insurance is closely monitored with regard to contractors and any contracts that are entered into with the association. If that contractor cannot demonstrate that they have that coverage, that contract should never be approved or entered into by the association. Problem provisions in vendor contracts. Normally, we would recommend that we review contracts, especially if they're larger contracts. And I say larger contracts, it would be, for example, landscape. Well, here, I can imagine what your landscape bill is. You have a lot of stuff to be taken care of. But when you get into large numbers for contracts, dollars and long-term For example, landscape contracts tend to be 1 to 2 years, usually 1 year, and then an automatic renewal unless otherwise canceled by the directors. It's very important that you actually have your council review that contract, especially if the contract is presented to you by that contractor. Every contractor is going to have things in favor of themselves as much as possible. You got to make sure that the association is protected as much as possible. And that's why I do recommend that that's reviewed. The problem provisions on page 14 of this presentation just kind of gives you an idea of things that you need to look out for with regard to most contracts, even ones that you don't have reviewed. But you want to make sure that you understand what the term limit is. Normally they're 1 year, but most of them have automatic renewals built into the contract. You have to be very cognizant and aware of that. One of the things that you will also see a majority of the time in contracts is they'll have a 90-day cancellation policy, meaning that 90 days prior to the end of the contract, you have to provide them written notice of cancellation. That's way too long. I would never recommend more than 30 days for cancellation. And that's a term that you can actually amend or adjust with the contractor, and they normally will agree with it. That also goes with regard to review of payment of actual invoices that are submitted by the contractors. They tend to build into their contracts usually a 15-day turnaround for challenging the contractor's invoice. You can't do that as an association because you can't conduct business but every 30 days. So at a minimum, you have to set 30 days as the time for turnaround for challenging any type of contract. Automatic price adjustments. When the automatic renewal happens, they tend to build that in as a percentage increase. It's not necessarily anything wrong with that, but you got to make sure that it isn't an unrealistic percentage increase. Normally, it's just a cost of living, which is like 3% or something is usually the maximum increase that I would ever recommend. No oral terms. Everything has to be in writing, including any types of change orders or any other actions taken by a contractor that falls outside the scope of the contract which they're entered into. You guys have to get a written change order or some modification or amendment to the contract. You cannot direct them to do something outside that contract because it isn't technically covered, nor has it been validly approved by the board. It also protects you in the event that the contractor does something without authorization that falls outside their contract, that you don't end up having to pay the cost for it because they made that error. Insurance, which we discussed. Indemnity provisions of the actual association, warranties, bonds. Again, I would recommend at least initially for anything, and I'll say in excess of $100,000, you definitely have to have, and so your council review that contract. It's in the best interest of the association for that to be done. At some points, we actually end up negotiating the contract with the contractor because they engage their counsel to negotiate the terms of the agreement, but we try to get them as much in favor of the association as possible and protect the association as much as possible. Rules enforcement. With regard to community associations such as yours, there are governing documents that you have to follow. Governing documents include the Articles of Incorporation, the bylaws, CC&Rs, and rules and regulations. Keep in mind that rules and regulations are 100% controlled by the board of directors. They can I'll be honest, each time a new board is set, they can make new rules or they can adjust existing rules based on what they believe is best interest of the association. Those rules are equally enforceable, provided that they will not contradict what is required in the CC&Rs or in the bylaws. And the enforcement of those rules has to be equivalently enforced against each member. One of the mistakes, and I won't say mistakes, but there are potential possibilities in a lot of communities where a particular individual stands out and the board will find them in violation more frequently than someone else. That's not legal to do. If they are violating it, that's fine, and you can do violation notices, but you have to make sure that you're enforcing those same violations or the rules, regulations, and the CCNRs equivalently across the board against all membership. With regard to enforcement of the actual rules and CCNRs, there is a lot of leeway with regard to board of directors' authority in that. Someone who may have violated the rules and regulations is called in for a disciplinary hearing may not actually have to be fined. You don't have to fine everyone. You can waive that fine or find that the fine isn't necessary because you've now warned the person in that hearing, and they've made some representation that they're going to correct their behavior. What I would do in that point is recommend that the board take it, basically table it, so that they don't actually institute fine and do a recall on that same person at a later date if the violation isn't corrected. At which point then you fine them. But you do have leeway with regard to that. There is a fine schedule that you guys have adopted for the association. I think that you guys would probably want to take a look at that and make sure that you understand how the fine process works. In addition to fining membership, you can actually do suspension of rights for use of common areas, and you can also do a suspension of voting rights as mechanisms to get compliance with the governing documents. If you have to go beyond that, the process that you guys, so that you're aware, if it goes past the disciplinary hearing and it continues, the association will send out an invitation to you or a request to you to attend an IDR, which is internal dispute resolution. Internal dispute resolution is a very good thing. It provides an opportunity for you to meet with a specified board of directors. They may appoint 2 or 1, depends on how they want to do it. But it can be the entire board, but usually not. So that you can sit down and discuss potential resolution with regard to that violation with those board of directors, and hopefully come to some type of conclusion that's acceptable to both. The resolution is put in writing. Both parties will sign it. Understand that even if those 2 board of directors come to some type of resolution in that IDR hearing or meeting, that they actually have to present that to the entire board for approval. They don't have authority to just unilaterally enter into that agreement. They will strongly recommend it because they have worked that hard to get there, but there's not 100% guarantee that it's going to be approved. If you aren't satisfied with regard to, or the board doesn't resolve that in an internal dispute resolution, the next step that the board would take would be actually to invite you to mediation. Invitation to mediation is a good opportunity. It also is a lot less costly alternative for a member and the board of directors and the association. What happens is that the association invites you to mediation. There is a neutral third-party mediator that is selected by both parties by agreement. That person is usually a retired judge or attorney or someone else that has very good knowledge with regard to the operations of an association. And they will sit down and work with the parties to try to resolve that thing in a settlement agreement between the parties. That is a very, very monetarily beneficial mechanism and method for the resolution, and I recommend you guys strongly consider that as an option. Understand that you do not, as a member, have to attend an IDR hearing if they were invited by the board. If you ask for an IDR hearing as a member of the board has to have the IDR hearing. Similarly, with regard to mediation, if a member requests mediation, the board has to enter into mediation. If the board requests mediation with a member, the member does not have to enter into mediation. But I will say this, if you avoid or do not try to do alternative dispute resolution, immediately file a complaint in the Superior Court with regard to any violations or anything with regard to the association, the judge is not going to look favorably on someone who avoids ADR, alternative dispute resolution. In fact, most likely that judge is going to force you to go to mediation. And you now have on top of that a cost of an attorney filing or preparing a complaint for you and the attorney. Not that you can't have an attorney attend with you in either of those alternative dispute hearings. So that is something that you want to keep in mind, and as the board, I strongly recommend that you try to do that as much as possible to avoid running up costs for legal fees and with regard to costs for litigating anything that may be necessary to resolve. Committees. Your association is somewhat unique, and I actually was just reminded that the association requires, with regard to committees that are formed for your association, that 2 board members have to serve on that committee. That is an unusual requirement to have 2 board members serving on the committee. And that puts a lot of burden on your directors that I think is not necessarily the best way to go about doing that. I understand the logic of having a director be present during committee meetings to at least kind of monitor them, but 2 is a lot. But that is something that can be done. Committees are for purposes only. They are for recommendations of specific issues that the board deems to be needed to be investigated. So if there's specific work that needs to be done, for example, resurfacing all of your streets inside your gated community or any of the paving, that they would appoint a committee for that purpose to investigate the best solution on how to deal with that or potential options that are available to the association. And at that point, once they've decided what that recommendation is, they go to the board, recommend their position, or present a written report to the association directors for decision making. They don't have decision-making authority, so to speak. They may have the opportunity to vote amongst themselves in the committee as to what they're going to present. And most likely that is what's going to happen if you have a 5-member committee and you have 3 members vote to do one thing and the 2 members vote to do another. Just like with the board of directors, the majority rules, that is a position the committee should take and present to the association directors. The decisions of the committee are not binding on the association. Again, they're just recommendations. They don't have authority to actually cause what they recommend to happen. There are several types of committees. There's standing committees. Normally that's like an architectural committee that may be identified in your CC&Rs. There's special committees that are specifically for single purpose, and then there are executive committees, which hopefully you guys will never have to deal with. Executive committees, just so you know, executive committees is a mechanism in which you set up in the actual board itself a separate committee to functionally operate and do certain aspects of work with regard to the association that certain directors may not be then participating in. And that usually goes to if there is what they call a rogue director. The rogue director is someone that is causing so much problem for the association and so much discourse with the association, disclosing of privileged information from meetings, for example, executive sessions, that they are disclosing information and causing waiver of privilege if they're doing anything that is in breach of their duties of fiduciary or duty or loyalty, that you can actually form an executive committee within the association to exclude that person from specific business that's conducted by the association, but for a very limited list of things that they are mandatorily required to be participants in. So that's an extreme solution. Should never happen. All your directors are excellent people. They all have excellent backgrounds. You have a duty to prepare the budget. Normally that is handled with between the association management assists, and normally will be done by accountants. If you guys are big enough, then probably some type of accounting company would assist. If not, internally they would have someone at the management company to assist doing that. You have a duty as a board to invest with regard to preservation of capital. So your reserve fund, you have to in some way protect that, but also it is important that you don't just put it in a debt account. You can invest them in CDs, probably not mutual funds. I don't know if I recommend that. But that's something that you can consider with regard to advisement from from other experts to determine what you do best to preserve those funds. You also have to be able to have that money be liquid to the extent that you can actually liquidate in the event that you need the money for emergencies. You're required to review finances, which we already discussed, and that's normally done by the treasurer. But all the board members should at least be constantly aware of the finances. They also require that the board of directors is tasked with filing the taxes on behalf of the association. You as board of directors have a duty to collect assessments, penalties, interest. That is one of the primary purposes of board of directors, is to make sure that assessments are paid. In order for our association to operate, everyone needs to contribute their share of the assessments. Assessments are based off of the budget most of the time on the coming year that will gauge whether they're increased. There are associations that will freeze their assessments at a certain dollar value, thinking that they're being nice guys to their fellow members by not increasing the assessments and trying to relieve them of the anxiety of having to pay more money for the assessments. Problem being is that, as with everything, every year everything gets more expensive. At some point, if there comes a time in which you have to do some major repair, and you haven't been increasing your assessments to meet with the budget requirements, you're going to end up getting a special assessment, which is going to be far more devastating monetarily to the members than if you just incrementally increase your assessments, normally just a cost of living increase of assessments on a yearly basis, which is has far less of an impact on the membership than a special assessment, which then is paid on top of your normal assessments. On page 23, we have an example of a code of conduct for directors and committee members. We put that in there for you as directors to at least review and consider. It is essentially I'll say a contract to a certain extent of agreement between the board of directors that they'll conduct themselves in a specific way. There is a requirement for it's normally voluntarily entered into. You don't have to enter into it unless the bylaws are amended to require execution of a code of conduct for the directors in the bylaws, which is probably likely not to happen. And enforceability-wise, it's just more of informational for you as directors to understand, and it kind of highlights the issues with regard to duty of loyalty and fiduciary duties that we discussed earlier. I'm not saying that you have to do it, but it is something to consider for the board so that you guys understand what your roles are to each other. And that is it. If you guys have any questions, I'd be more than happy to answer any.